witnesses right now. All we are saying is that the DPP has that burden of telling us that these charges are lawful and within the bounds of the Constitution. Secondly, Your Honor, a trial is not a fishing expedition. The charge must disclose a known offense with clear particulars and connect the accused's conduct to that offense from the get-go. If it fails these basic tests, then the charge collapses on its own weight. Finally, under Article 52B, an accused person must be informed of the charges with sufficient detail. So, what we are saying is that the accused person ought to have known how her words amounted to offensive conduct under Section 94, which is not the case. If the DPP can't say that now, then the court has every right to stop the process. In short and in conclusion, we are not challenging the evidence. What we are challenging is the charge's existence as a valid document. If they insist on going to trial without a valid charge, that's like building a house without foundation. Circumstances, submit that charge is defective, and this person should be admitted to a personal cognizance. Yes. And they have conceded to that, to her being released.
Her personal vote.
I just wanted to mention an authority. Like the citation? Yes, Your Honor, the decision I'm talking about is the Supreme Court decision. The bench comprising of Barata, CJ, Ibrahim, Iwan, Anjala, and Rofi. And the case is Hussein with a double S, Hussein Khalid with a KH, and 16 others versus the Attorney General and 2 others. Citation is petition number 21 of 2017. And without making the arguments in respect of this court powers to enforce fundamental rights. So I'll refer the court to paragraph 118. Allow me to just paragraph 118. The law then, the Magistrates Court Act number 26 of 2015 has since been enacted. 691A and 2 of the Constitution to confer jurisdiction and for connected purposes. Section 8 vests jurisdiction in the Magistrate Court to hear and determine applications for enforcement of torture and cruel, inhuman, or degrading treatment or punishment, and freedom from slavery as guaranteed in Article 25A and B of the Constitution. The jurisdiction of the Magistrate Court does not also extend to determination of claims for compensation for loss or damage suffered in consequence of a violation, infringement, denial, or a right of fundamental freedom in the Bill of Rights. 120. We therefore find and hold that there is now legislation that provides on how magistrate courts may determine allegations of infringement of fundamental rights. Though limited, the same is constitutional as an aggrieved person, while he might not on all allegations approach the magistrate court, still has recourse to the High Court, which is the court constitutionally empowered to address allegations or violations of the right.
Yeah, but just to distinguish it, on one point, and I agree we are bound by the decision of the Supreme Court, but will you not, in a very few minutes to come, enforce Article 49? We must. I may be seated where you are seated very soon.
Yeah, that's agreeable. The court can determine whatever terms and conditions.
So to that end, I think I'm alive to the provisions of Article 49 of the Constitution. So to give effect, I'll release the accused person for personal bond for 50,000. So the accused person will release the personal bond for 50,000, pending the termination of the application that we just. Next week, I'm swamped with so many matters. I'll be sitting when it's officially, I put my rulings within 2 days. But unfortunately, next week I'm not, so I'll do the other week, the week after next week. Fast. So that when I finish 29. So I'm proposing if 29 is convenient, we can come back on 29 at 9 if it's convenient.
Could we do it on first now that the accused will be out on board?
Yes,
On first, yes.
Yeah,
not convenient.
Yes, and we would request an hour like 10 or 11 so that you have done the other.
so let's first of all, like on the day.
Yeah, fast. Fast is okay.
Convenient. We come the week after.
So Friday.
First Friday, but it's not convenient. Can we come the week after?
Yeah, propose 11th of August. You know, we have a.
It's okay, you can come.
Yeah.
I would request this. In the absence of my lead counsel, I should assume I've taken the role lead the team, and I would request a more convenient because fourth and fifth are in a very complex issue. Yes, I would. I'm ready to propose 6th August.
Yes, that's good. Oh,
There is a proposal that appears to carry weight on our side. My lord, the 11th. There is a date that appears to be more convenient to every council.
Then let's go back. Let's go back to the 29th. Yeah. We could go back to the 29th if it was convenient to them. Yeah. My colleagues will represent 29th.
Yeah, it's okay. 25 is okay. Yes.
time allocation.
We also agreeing that you give us time indication, and we are preferring another hour other than 9. Let's say 11.
11 is fine. So that you don't bring us here.
So we have answers are cited and if you defend enough so that I don't give I get the authority that the one I
We can find it with you. What I'm reminding them is that whatever they give to you, they pass to the court. They should give us so that if there is something very pretty comparing, we could put in a comment.
Don't end there.
Yes.
Promise that you will serve us.
promise you will not
So
succeed.
I think just explain to
I think because of my years of practice, I've not met this where council says I have to give the undertaking before the court. When I'm already telling you with exchange.
Your Honor, it was on a light
Yeah.
note. I just
It's
say that
just that I
council
must
should also
give
say he
the
will give us.
Yeah.
I didn't mean harm.
Yeah.
Colleagues are very combative.
Yeah.
Senior, I'm sorry, I didn't disrespect you.
Oh, yeah.
Most obliged. Hey, leo mmekuja mbio sana.
Leo nimekuvamia.
Bana, I'll stop being friends with you. When you see your people, you start being hard on me. Yeah.
Haya, hebu ndugu ya kwetu.
That was a good one.
Akiwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi.
Sound Candy Talk Live News. Tonight.
Basi yule mtoto akasema ile siku moja mimi sijaenda kanisani na Yesu Kristo anakuja.
Because kuleta ndege ya Chief of Defense Forces down is not only negligence but criminal negligence.
Nilikuja hapa hadi ya Gong nikamwambia mchague Ruto.
Now, Article 157(6)(a), and again, this constitution can only be exercised in terms of the constitution. The Director of Public Prosecutions has powers to institute criminal proceedings against anyone, including the suspect, for any offense, including Section 94, alleged to have been committed before any court, including this. So that it is not for the defense to tell us that this offense is fit for bar brawls and drunkards. That's actually funny again, Your Honor. I saw you laugh. It's actually funny. The person who determines whether it is a drunkard should be charged with this offense and not this one is constitutionally vested with the Director of Public Prosecution, currently Mr. Renson Ngonga. So if that is correct, if they are unhappy with this offense, they can propose a better offense which fits, the stature of the suspect. But for now, we want to charge the suspect. In fact, Mr. Wakuta wonders why we're charging their client with an offense for 5,000. We are willing to charge her with another one for 1 million if they recommend. But for now, we are charging her with one where the fine is 5,000. That's actually a constitutional argument. As I conclude, I am going back to Article 24 of the Constitution vis-a-vis Article 33 of the Constitution. The third argument by the defense is that if you allow these charges to stand, then the plea will be unconstitutional. This is the first time I've heard that a plea can be unconstitutional. But in constitutional law, we have had a lot of things. It is admitted by both sides that rights outside Article 25 can be limited in an open and democratic society. It is not denied that Kenya is an open and democratic society. Then Article 33 gives the right it will be, I'm reminded by my colleague. Of Article 33, 1 and 2. That in, Your Honor, all this discussion culminates back to Section 134 of the Criminal Procedure Code. That all that is required of the prosecution is to have a statement of the offense. We have that. To have the particulars of the alleged offense, we have the allegations here, which we are saying the suspect said. There is no requirement under Section 134 that the quality must get to certain level. It should just be sufficient to understand. And they understand. The only disagreement is that it does not disclose threatening, abusive, or the part. If you find for us that in fact we have met the provisions of Section 134 of the Criminal Procedure Code, then the defense, because we will meet with them, I'm sure they are experts in this area, must be stopped from this practice of forcing us towards mini trials instead of taking a plea. We urge you that the best approach should be that plea should be taken, and then witnesses should be cross-examined. Then the court makes a determination whether or not the elements have been proved at Section 210 acquits, or discharges or acquits, and at Section 215 acquits. That has, this matter is not right. The application is not right as we speak. In conclusion, Your Honor, if the defense think that there has been an alleged violation of rights of the suspect outside Article 25, this building also hosts the High Court of Kenya in terms of Article 165 of the Constitution. They know the proper pleading and the proper forum. Allow me to finish on a good note. We were not going to oppose bail if plea was taken, number one. And we agree with the arguments of counsel that this offense is a misdemeanor, and I salute you, sir, because that came out towards the end, that because it's a misdemeanor, it would be illegal to hold the suspect pending other motions. We would, however, require that, request the court that you require that there is some personal cognizance or whatever form for her release. We thank you, unless there's a question.
So on the flip side,
yes.
If it's about speculation, I believe they what they are looking to is right. And so the DPP has a right for it.
Yes, that's correct. And that's what 135 says, now that you brought it, Your Honor, that if the court finds that we have not met the test in 134, then you go to 135.
I wanted to say that because I want to give them an
Yes.
to address that issue.
Yes, that's right.
Thank you.
I'm most obliged.
Any other on your end?
My people say that I carry the donkey. I hope I've done them.
Yes, I will briefly respond to the issues raised by my learned friend, then I invite Mr. Gerard when the chairman is addressing it. There is no misconception that, but I want to begin that nilimwacha aongee in talking. Yona, you have been told that section 94, subsection 1 is what council is defining as normative. That's a misconception. That provision does not qualify to be defined by that doctrine. The simple reading of the word normative means it relates to a norm, a rule, or a thing that should be. So if you were to argue, therefore, that section 94, subsection 1 is to be constituted or to be construed as a normative derivative vis-a-vis the provision of Article 33, the question therefore posed to the court, therefore, in determining the norm in section 93 would be, in normal circumstances, how would court regard such a statement captioned by the charge sheet? What norm is arising or accruing from the particulars of that charge? And must that norm conform to the provision of section 7 of the sixth schedule? Again, simple reading of derivative means which can refer to something that is derived or taken from something else. It's about, that's to say, section 94, subsection 1. If you were to juxtapose it to the normative derivative doctrine, vis-a-vis cannot then be said to have accrued or the provision of, and that is why, of course, deliberately so, because he does not the fact that section 7 of the sixth was enacted so that it can assist the court where an amendment has not been initiated by the relevant authority. I concede it's only Parliament that can legislate. Yes, that I concede. But in the absence of a legislation, what is the import of section 7 of the sixth schedule? And what is the scope of the application of section 7 of the sixth schedule? If the scope is not such, the scope of application is not such as this one. The reason why Parliament, the reason why the people of Kenya enacted section 7 of the sixth schedule, they were alive to the fact that not all laws that may suffer amendments or repeals upon the enactment of the new constitution. And therefore they created an avenue for a magistrate or a judge to have the flexibility of dealing with a situation as and when it arises. Of course, my learned friend would want to argue, on the contrary, that it calls you, it limits you and makes you rigid to the interpretation. That is not the expectation. He has addressed you on the question of the repeal. If even when a repeal has not accrued of a section, that is not in conformity with the Constitution, the obligation of the court, faced with such a challenge, is to make sure that that section does not defeat the purpose for which the Constitution was enacted. And then where do you get that purpose? You get that purpose under Article 10. The benefit of my learned friend, who seldom practices constitutional law, Article 10 says, the national values and principles of governance in this article binds all state organs, state officers, public officers, and all persons whenever any of them applies or interprets the Constitution. That is not what we're inviting you to. Enact, applies or interprets the law. That is what we're inviting you to. This law, Section 19, Section 94, subsection 1. And at this juncture, Your Honor, you might want to seek the aid of the interpretation, the tools of statutory interpretation. And one of the tools I suggest that you apply in these circumstances is the golden rule.
Sorry, Your Honor, I hope we are not opening new areas of arguments because ours is closed. So counsel should just stick to what came up and the law so that we are not able to require to.
He addressed you on the applicability of Article 10, Your Honor.
Yeah.
And I have simply dealing with the question of Article 10. I invite you to apply the tool of the golden rule. In 1930, when this section was being enacted, what was most relevant was the mischief rule that Parliament, as at that time, wanted to address. And this case is a Parliament granted that this country was accepted, and Her Majesty government wanted to guard, control, and subjugate the people of Kenya. Okay, I'll elaborate on that, but I know I could have not. Now that we have the new constitution, so that you may not resort into the absurdity that the DPP is inviting you to, you must apply the tool that enhances the enjoyment of a right other than limit. And that you're being invited by Article 19, 20, and 21. To argue that Section 8 of the Magistrate Code limits you, again, would be to miss the point. There's no possibility that the Constitution can give you under Article 10, which provides, again about these values, and I want to just mention the value of human rights. That when seated there, Your Honor, you are bound by the values of human rights. And where do you get these values from? The Bill of Rights. So are you then supposed to apply the Bill of Rights selectively, exclusively, and in a limited manner? If you're then being invited that the only jurisdiction is under Section 8, subsection 2, then how are those rights contemplated? They are capable of being denied, violated, threatened, or infringed. By the deliberate use of the word threat in the section, threat, violation, denial, or infringement invites you to holistically analyze the entire concept of human rights. It does therefore not limit you under Section 8, subsection 2. Otherwise, how can the Constitution give you and then a legislation take? Again, you must interpret it in a manner that advances the enjoyment of that right other than limiting it. Again, that is again on the doctrine of the law, that you expound the law in a manner that facilitates the achievement of that objective. I will again address you on Article 50, Clause 2, and this, I'll leave it at this and then invite Mr. Kirago, because this article, Your Honor, tells you that when a subject such as honorable member is brought before you, must be informed of the charges with sufficient details to answer. So the DPP does not just have the liberty of crafting anything and anything goes. That as long as you are here, the only obligation is to answer.
Your Honor, this argument was made by counsel when they were making their argument. What we understand, let me finish, sir. Let us just have courtesy. What we understand as a response, just sit, I'm finishing and then you.
Yeah. You know that they don't have a place to sit.
No, you, it's okay. He has a place. So we are pleading with them. We are pleading in response so that we don't regurgitate. We just issues that have arisen.
Okay, I'll abandon that argument. I'll take that objection so that you. Yes. No. There's no issue over it because if I was to read, and again for the benefit of my learned friend who seldom refers to it.
So sorry, this second time I'm not taking it. I am not. I am an advanced master's holder in constitutional law. It's not. Should not throw the shades.
It's one thing to hold a master's, and yes, and we are not surprised by those credentials, but surprised by the inability to apply the same.
Now this is causing us damage here. I am not the kind of person to be intimidated by people like this and so this court should just direct you that he respects the court if he doesn't want to respect me, and if he doesn't want me to lose my respect for him today. Because I take my education seriously, having listened from Islam, that I can't allow someone else to make shades against me. So please, just respect me. Yeah. Yeah.
Well, yes, Your Honor. There is no judicial overreach, because the philosophy behind the enactment of Section 7 was in the mind of the drafters of the Constitution that there exist laws and there was need and the necessity to save those laws so that they may not all be considered to be inconsistent with the Constitution by virtue of Article 2 of the Constitution. And that is why, Your Honor, Section 7 says all laws in force immediately before the effective date continues in force and shall be construed with the alteration, adaptation, qualification, and exceptions necessary to bring it into conformity with this Constitution. So this is an invitation to any judicial officer who sits to adjudicate over a dispute. Additionally, Your Honor, this is also in respect to any other state organ that is invited to apply laws. For example, the procurement laws that were enforced before then, or perhaps the marine laws that were enforced before then, or any other law. So there will be no judicial override, Your Honor, if you are then to apply, because that is a constitutional invitation that you cannot avoid. Most obliged.
I think the chairman has just 2 minutes.
Your Honor, I don't know whether this would be an interruption of the proceedings.
Mr. Owiti has a habit of always rising when I rise. He can stand, I can submit when he's standing. I don't have a problem. But let me make my submission.
Your Honor, I was just going to make a small request. I am not your enemy, sir. I was going to make a request so that before they are done, we let them finish. I just want to mention an authority. I'm not arguing. Just bring it to your attention if you allow me to read a paragraph, so that as he responds, they also tackle.
We are beyond that.
I am allowed to make an application to reopen. So
he has already closed his case.
yes. Okay, that's fine.
Yes, that's the rule. He cannot be allowed to be sitting.
No, I think the court has directed. The court has directed. The court has directed.
Yeah, very briefly, There is a suggestion that we are inviting you to a mini trial prior to plea. In many words, that's our point. We are not asking you to evaluate any evidence. We are only asking you to look at the content of the charge sheet in terms of the wording, and look at the relevant section of the law that is said to be based, and make a judicial determination in accordance with section 89, subsection 5 of the CPC. Also, section 134 of the CPC. That is all what we ask. When prosecution brings a case before you, a charge sheet that is before you, and a suspect before you, it is in exercise of the ODPP's power under Article 157. We had talked about it. And as I had said earlier, this power must not be abused. Indeed, and Mr. Whitty knows this very well, that what sub-article 11 says is that power of the DPP in exercising the powers conferred under this article, the DPP shall have regard to the public interest, the interest of the administration of justice, and the need to prevent and avoid abuse of the legal process. So, when a charge sheet is brought before you, that is clearly an abuse of the process, Your Honor, that is a charge sheet that you should reject, and the court gives you, the law gives you that power. Lastly, our learned senior, who is not with us today, Mr. Kibe Mungai, told us in another court setup, that there is a reason why, under the new constitution, the bar on this side, the defense, the prosecution, and the bench was made to be advocates. We no longer have police officers on that side, advocates, and then there used to be district magistrates on that side. Those days. Now we have advocates. So that when materials are brought before the court, the level at which we interrogate them is not the basic level. We should present before the court and get before the court, and the court applies its mind, its legal mind, to assess a situation so that we prevent and avoid abuse of process. Why do I say this? There was a suggestion by my learned friend that when a charge sheet is brought before you, your role is to tell the accused person plead guilty or not guilty, and then evidence will come to prove or fail to prove. That is not what the Constitution envisages. Envisaged a situation whereby all the parties would have some basic meeting of mind as advocates that indeed this charge sheet, we may fail in evidence, and this one is also in the decision to charge guidelines. We may not attain 100%, but there's some reasonable. The charge sheet is in the direction of something that we can prove. So you're being told, yes, there's nothing threatening, there's nothing insulting, there's nothing offensive, but nonetheless, let her take plea. We will move along and see what we will do along the way.
I hope we didn't say that. I hope the record will help us.
Let's move. We'll learn where we find ourselves. Decline that invitation and find that this is not a proper charge that the person should take. I invite my
Thank you. I will be brief, and I will start by quoting Justice Odunga in Republic versus Director of Public Prosecutions and another, Spate Chamanlal Kamani, whereby Justice Odunga said this: the seat of justice is a hallowed place and ought to be preserved for those matters in which the protagonists have a conviction and stand a chance of seeing the light of day. And he adds and says that a trial is neither a showbiz nor a catwalk. Why am I saying this, Your Honor? The DPP under Article 157 has the prerogative to charge. Then again, it's not for sport. It must be exercised reasonably, lawfully, and within the constitutional bounds. Your Honor, the DPP, the office of the DPP, is assumed to be sane and rational. We operate on the gracious presumption that the office of the DPP is sane. But the prerogative to charge, Your Honor, isn't a license to experiment. Short, Your Honor, we are telling you that you don't need to taste the meal to know that something is off. Even the smell of it can tell you that there is something that is off. Finally, Your Honor, two issues. We are not asking the court to test the evidence. What we are inviting the court to do is to test the lawfulness and the sufficiency of the charges. Simple. A criminal trial is only justified where there is a properly framed charge that discloses an offense in law. So we are not saying that we should call witnesses right now. All we are saying is that the DPP has that burden of telling us that these charges are lawful and within the bounds of the Constitution. Secondly, Your Honor, a trial is not a fishing expedition. The charge must disclose a known offense with clear particulars and connect the accused's conduct to that offense from the get-go. If it fails these basic tests, then the charge collapses on its own weight. Finally, under Article 52B, an accused person must be informed of the charges with sufficient detail. So, what we are saying is that the accused person ought to have known how her words amounted to offensive conduct under Section 94, which is not the case. If the DPP can't say that now, then the court has every right to stop the process. In short, and in conclusion, we are not challenging the evidence. What we are challenging is the charge's existence as a valid document. If they insist on going to trial without a valid charge, then that's like building a house without foundation. Circumstances, submit that charge is defective, and this person should be admitted to a personal recognizance. Yes. And they have conceded to that, to her being released.
A personal vote.
I just wanted to mention an authority. I give the citation. Yes, Your Honor, the decision I'm talking about is the Supreme Court decision. The bench comprising of Baraka, CJ, Ibrahim, Ivan, Manjala, and Yoki. And the case is Hussein with a double S, Hussein Khalid with a KH, and 16 others versus the Attorney General and 2 others. Citation is petition number 21 of 2017. And without making the arguments in respect of this court powers to enforce fundamental rights. So I'll refer the court to paragraph 118. Allow me to just paragraph 118. The law then, the Magistrates Court Act number 26 of 2015 has since been enacted. 69(1)(a) and 2 of the Constitution to confer jurisdiction and for connected purposes. Section 8 requests jurisdiction in the Magistrate Court to hear and determine applications for enforcement of torture and cruel, inhuman, or degrading treatment or punishment, and freedom from slavery as guaranteed in Article 25A and B of the Constitution. The jurisdiction of the Magistrate Court does not also extend to determination of claims for compensation for loss or damage suffered in consequence of a violation, infringement, denial, or a right or fundamental freedom in the Bill of Rights. 120. We therefore find and hold that there is now legislation that provides on how magistrate courts may determine allegations of infringement of fundamental rights. Though limited, the same is constitutional as an aggrieved person, while he might not on all allegations approach the magistrate court, still has recourse to the High Court, which is the court constitutionally empowered to address allegations or violations of the right.
Yeah, but just to distinguish it, on one point, and I agree we are bound by the decision of the Supreme Court, but will you not, in a very few minutes to come, enforce Article 49? We must. I may be seated where you are seated very soon.
Yeah, that's agreeable. The court can determine whatever terms and conditions.
So to that end, I think I'm alive to the provisions of Article 49(2) of the Constitution. So to give effect, I'll release the accused person for personal bond for 50,000. So the accused person will release the personal bond for 50,000, pending the determination of the application of justice. Next week, I'm going to so many matters. I'll be sitting when it's usually I put my rulings within 2 days. But unfortunately next week I'm not, so I'll do the other week. The week after next week. Fast. So that 29. So I'm proposing if 29 is convenient, we can come back on 29 at 9 if it's convenient.
Could we do it on first now that the accused will be out on board?
Yes,
on first, yes.
Yeah,
not convenient.
Yes, and we would request an hour like 10 or 11 so that you have done the other.
So let's first of all I do on the day.
Yeah, first is okay.
Then the week after. Convenient. We come the week after.
Surprise.
Surprise, but it's not convenient.
Yeah. Propose 11th of August. I know we have a.
You can come.
Yeah.
I would request because in the absence of my lead counsel, I should assume I've taken the role with the truth, and I would request a more convenient because fourth and fifth are in a very complex issue. Yes, I would. I'm ready to propose 6th August. Yes.
Yes, that's good. Oh.
There is a proposal that appears to carry weight on our side. My Lord, the 11th. There is a date that appears to be more convenient to the council.
Then let's go back. Let's go back to the 29. Yeah. We could go back to the 29th if it was convenient to them. Yeah. My colleagues will represent 29.
Yeah, it's okay. 29 is okay. Yes.
Time allocation.
We also agree that you give us time indication, and we are preferring another hour other than 9. Let's say 11.
11 is fine. So that you don't bring us here.
So we have answers of scientists and authorities. If you find enough to so that I don't give, I get a different authority than the one in life.
We can find it through. What I'm reminding them is that whatever they give to they pass to the court, they should give us so that if there is something very completely comparing, we could put in a comment. Yes.
Promise you will not serve.
So I think just explain.
I think because of my years of practice, I've not met it this way. A counsel says I have to give the undertaking before the court. When I'm already telling you we'll exchange.
Your night was on a light note. I just say that counsel should also say he will give us.
Yeah.
I didn't mean harm.
Yeah.
Colleagues are very combative. Senior, I'm sorry, I didn't disrespect you.
Oh, yeah.
Most of like, hey, leo mmekuja hiyo sana.
Leo tumekuvamia.
Bana, I'll stop being friends with you. When you see your people, you start being hard on me. That was a
Akiwe ngao na mlinzi, na tukae na undugu, amani na uhuru, raha tupate na ustawi.
You know my history in the matter. Good job.
Tunaweza pata Tunapita huko nyuma. Chunge tu, si lazima tuishike. Just watch it.
Okay, Amepost status yake hapo huko.
Doi yangu. Yeah. 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 Lazima.
Chaki. Hiyo unajua ni kwenda naenda.
Unataka kwenda? So unataka aje? Unataka aje? Utarekodi press.
Mimi sitarekodaje niende.
Check. Unaenda?
Narudi kwa.
Nadai videos.
Wow, sawa. Kuna yenye umerekodi?
Kuna yenye nimerekodi.
Sawa.
Nadai ya charge.
Sawa,
Si bro.
Sasa nimekushika kumbe. Aje young man.
So I was
okay. 1-2. Kenya 1-2.
To go live. So ladies and gentlemen, we've been here on the issues around Jayne Kihara, who was unfortunately arrested yesterday. But the charges, we are surprised that the charges that were brought here by the ODPP cannot even hold water. They could not substantiate what they are saying. So Mheshimiwa has been released on a bond of 50,000. But what we are asking, our main concern is why would the government take time to frustrate leaders and make the country look like it's a joke? Because we cannot have members of parliament being harassed in this way and charges that do not hold water. The other day we saw young people, a group of young leaders and youths being charged with terrorism. We cannot operate this way. We are putting our country in a very bad light internationally. And the president and the Kenyan regime should come back to their senses and run this nation according to the constitution in respect to the law. My name is Ken Babu.
Ahadi Kenya.
My name is Nick Mwangi, the SG Kenya Ahadi Party. Well, you know, I'm telling many Kenyans, they came for the young people. Now they have come for our parents. We are not safe. And that's why we are saying this government has to go. Today, with my friend Ken Babu, because we are in the United Opposition, we have come here to support Mheshimiwa Jayne Kihara. And all these parties, Kenya Ahadi Party, Wiper, DCP, DAP, are singing one song. One time is real, Kasongo anaenda nyumbani.
Sound Candy Talk Live News.